Hello, I am Chief Justice Raheem Mullins. On behalf of the Connecticut Judicial Branch, welcome to jury service. Later this morning, you will take part in the important process of jury selection. Whether or not you are ultimately selected to serve on a trial, your participation today is vital to our system of justice. This video has been prepared to help you understand our process and to let you know what to expect throughout the day. Again, thank you for your service.
When people first get a summons in the mail for jury duty, a lot of people immediately think, oh boy, I gotta leave work, I have to find a babysitter, and a lot of times it's an inconvenience to some people.
I think most people's reactions when they get that summons in the mail is, oh, it's my turn again. Great.
I know it's kind of a duty, it's an opportunity, and I realize that, gee, if I were in a court case, I would want someone to say yes to that and to come and do the best job they could.
People think it's something that they got dragged into that they have to do, but actually it's something they should be happy that they can make a difference.
Jurors often ask, how did you get my name? Or why was I selected? The Connecticut Judicial Branch selects jurors each year from lists obtained from the State Department of Motor Vehicles, the Department of Labor, the Department of Revenue Services, as well as the Central Voter Registry of the Secretary of the State. These lists are combined to form one single list from which jurors are randomly chosen. Selecting jurors from multiple lists helps ensure that jurors represent a fair cross-section of the community. One common concern is what to provide your employer to prove that you were in court for jury service. After completion of service, you will be sent a certificate of recognition to provide your employer. If your employer requires proof of service sooner, please ask the jury clerk for a note. Please know that the law requires your employer to allow you to serve and that you cannot be disciplined or terminated for serving as a juror.
Connecticut's jury selection process is the only court system in the country where the right to question jurors individually is protected by the state constitution. This process is called the voir dire, which is an old French legal term meaning to speak the truth. During the course of the day, you may be assigned to the voir dire in a criminal or civil case based on the trial schedule in this courthouse today. The people involved in the trial will be introduced and you will hear the names of possible witnesses in case you happen to know any of them. Then you will be called into the courtroom one at a time to be questioned. The questions asked will depend upon the kind of case that is on trial. No one will try to confuse or embarrass you. There are no trick questions, and none of the questions will be a test of your legal knowledge. You are not required or expected to have any knowledge of the law. Most of the questions will be fairly straightforward. You may be asked about your background and whether you know anything about the case or the people or locations involved. You may be asked about your feelings toward the type of case that is on trial or any experiences you have had that may be similar to that case. It's important to know, for example, if you have some specific knowledge about what happened in the case, or if you know any of the witnesses, or if you are familiar with a particular location. If you do, that might affect your ability to be objective in deciding the case. Another common question is whether you or any of your close friends or relatives have been previously involved in the court system in a criminal or civil case. Of course, the attorneys don't intend to make you uncomfortable or to ask questions simply to pry into your personal affairs. You should understand that the attorneys are asking the questions because it is vitally important that each person accepted as a juror will be fair and impartial toward everyone involved in the case.
Hello, I'm Judge Elizabeth Bizzuto, the Chief Court Administrator. Remember, you're not expected to be an expert in the law. If you don't understand the question during the voir dire process, ask to have it repeated or explained. The judges and attorneys want to be sure that your experience in the courthouse today is a good one and worth the time and effort you've put into it. When the attorneys have finished interviewing you, you'll be excused while a decision is made whether you will serve as a juror on that case. You then will be informed of the decision. If you are selected to serve, court personnel will provide you with the information you will need. If you are not selected, you'll be asked to return to this assembly room for possible service on another case. Please do not feel slighted or offended if you are not selected. There are many reasons why a person may not be chosen for a particular trial. It does not reflect in any way upon your honesty, your character, your ability to be fair, or your ability to be a good juror in another case.
So when we went into voir dire and they started to ask the questions, those questions were very reasonable. They really go out of their way to introduce themselves and to be informal in a way to make sure we're comfortable.
They started asking questions about me and my circumstances and where I, my children, or, what I do for a living and what my understanding of things were. They actually made it very relaxing, just like having a conversation like I am right now.
They asked me about my history, they asked me about my education and my experience with, situations like this, the things that I've heard and dealt with.
Although you are not expected to be knowledgeable about the law, it may be helpful to you if we provide a brief explanation of some general principles. We hope that this will remove some of the mystery from the process and make you more at ease during the voir dire. The judge's function is to decide the legal questions and explain the law to the jury. The jury in a trial must follow and apply the law as the judge explains it to them. So whatever personal beliefs the jurors might have about what the law should be, they must put those personal beliefs aside and apply the law as the judge instructs. Your function as jurors is to decide the facts of the case. This is a great responsibility. Your judgment on the facts is final. You must judge the facts without prejudice or bias after you have heard and considered all the evidence, keeping an open mind until all the evidence has been presented. You must decide the facts based only on what you have heard in the courtroom. If you are selected as a juror, you must avoid all communications to or from anyone about the case or any issues arising in it. This means all types of oral and written communications, including electronic communications, such as emailing, blogging, texting, tweeting, and posting on Facebook and other social networking sites.
No, I don't think the police report was accurate.
During the trial, you'll hear testimony of different witnesses, and one of your most important and challenging tasks is to decide what testimony is the most believable and what testimony is not. In the eyes of the law, all persons who take the witness stand start off on an equal footing. No witness, because of his or her position in society, his or her occupation or lack of one, or his or her lifestyle, is automatically considered a better witness or more truthful than any other witness. In any trial, civil or criminal, there may be situations that evoke your sympathy. In a criminal case, you may feel sympathetic towards a victim, a witness, or perhaps even the accused. In any civil case, you may feel sympathy for a person who has been injured or for a person who has been sued. These feelings are not at all unusual. They are perfectly natural, but the law does not allow a case to be decided on the basis of sympathy. In other words, if you feel sympathy, you cannot use those feelings in deciding the case. As a juror, therefore, you must decide the case solely on the basis of the facts that you find to have been proved in the law as the judge explains it to you. In both criminal and civil cases, the decision of the jury must be unanimous. That is, all jurors must agree. In order to reach a unanimous decision, each juror must also be willing to discuss the case with other jurors, listen to their views, and benefit from their thinking.
In the jury room, coming to that decision was the most difficult part of the trial.
What was your viewpoint? What's my viewpoint? How can we come to an agreement? How do we get everyone's viewpoint on the table?
I had to make sure everybody stayed calm and made sure that we stayed on track. And there were times it got heated, and there were times we had to sit down and step back and regroup.
And one member of the jury said, "I'm not comfortable with this." And we talked about that for a while, and another jury member said, "Well, but did you consider looking at it this way, from this other viewpoint?" And he looked at it for a while and said, "Yeah, okay, that makes sense. I'm comfortable now." And it all worked out pretty well.
If you are interviewed for service on a jury in a criminal case, there are 4 principles with which you should be familiar. First, every person accused of a crime must be presumed by the jury to be innocent. This means that the fact that the defendant has been arrested and charged with a crime and is on trial is not evidence of guilt or that the defendant has done anything wrong. and the defendant continues to have the benefit of this presumption of innocence unless the state proves that the defendant is guilty beyond a reasonable doubt. Second, in every criminal case, it is the burden of the state to prove the defendant guilty beyond a reasonable doubt. It is not enough for the state to prove that a defendant is possibly or probably guilty. The judge will explain to you what guilty beyond reasonable doubt means during the trial. Third, the defendant in a criminal trial does not have to prove that he or she is innocent. In fact, the defendant is under no obligation to prove anything at all. The state has filed the charges against the accused, so it is the state's responsibility to prove the charges if it can. In a criminal case, the state has to prove the defendant is guilty beyond a reasonable doubt to gain a conviction. Fourth, the defendant in a criminal trial has a right under our Constitution not to testify or present other evidence in the trial. Therefore, the jury cannot hold it against the accused in any way if he or she chooses not to testify or to present any evidence. If the jury finds that the state has proved its case, that is, that the state has proved the elements of the crime beyond a reasonable doubt, then the jury must find the defendant guilty of that crime. If the jury decides that the state has failed to prove any elements of the crime beyond a reasonable doubt, then the jury must find the defendant not guilty of that crime. If you are chosen to sit on a criminal case, a judge will fully explain all of these principles to you.
As we have seen, criminal cases are between the state on the one hand and the person accused of the crime, the defendant, on the other. Civil cases involve disputes between private parties. A familiar example of a civil case is one where someone who was injured in a motor vehicle accident sues the person who allegedly caused the accident. The suit is brought in order to obtain money as compensation for injuries and property damage. The person bringing the lawsuit is called the plaintiff. The person against whom the lawsuit is brought is called the defendant. If you are chosen to serve on a jury in a civil lawsuit, you will be deciding whether the defendant is liable to the plaintiff. If that is so, you will then decide the amount of money damages to be awarded. This civil law system is based on the idea of fault or legal liability. This means that a plaintiff is not entitled to collect money from the defendant just because the plaintiff was injured. The plaintiff must prove that the defendant was principally at fault, and also that the defendant's actions caused the plaintiff's injuries. The judge will instruct you as to the specifics of Connecticut's law on negligence. If the plaintiff proves the defendant was at fault and that the defendant's conduct caused the plaintiff's injuries or damages, the defendant is held responsible for those losses. The plaintiff is entitled to be compensated for those damages to the extent that money can do so. The plaintiff has the burden of proving the amount of damages. Damages may include medical expenses, lost earnings, pain and suffering, and permanent disability, and other losses proved by the plaintiff. One important difference between criminal and civil cases is the burden of proof. In a criminal case, the state has to prove the defendant guilty beyond a reasonable doubt, whereas the plaintiff in a civil trial has to prove his or her case by a fair preponderance of the evidence. Preponderance of the evidence is a legal term, which means that one side has shown that its testimony and evidence is more likely than not the correct version. This is a lower burden of proof than in a criminal case. And what about insurance? Under our law, insurance coverage that a plaintiff or defendant may have does not have any effect on that person's legal rights or responsibilities. So, the jury must decide the case without considering whether someone is insured or not. If you are chosen to sit on a civil case, the judge will fully explain these principles to you.
Madam Foreman, has the jury reached a verdict?
Yes, we have.
Please hand that.
To someone approaching jury service, I would tell them to enter with an open mind.
They need people that are willing to be there and basically serve justice.
Just go in and you give it everything you have, be honest, be positive about it, and everything should be okay.
So for me, it was very valuable. I also think that for the way we've put together our system of justice, it's the best way.
I'd be willing to do it again.
Thank you for being here today. We appreciate the time and effort and inconvenience that jury service entails. Your attention and willingness to take part in this most solemn duty is the cornerstone of our judicial system. The judicial branch has court service centers and law libraries in most of its court locations. Once you have completed your jury service, we encourage you to visit our centers and our libraries to see all of the services and resources they have to offer. Our court service centers are equipped with public internet access computers, phones, copiers, and helpful, knowledgeable staff, as well as many court and community publications and resources. Our law libraries also provide public computers, as well as access to a full range of legal resources and services, including print materials such as Connecticut statutes and rules, and many electronic resources such as self-help materials, publications, and videos. You are welcome to visit any of our law library locations once your jury service is finished. An informational pamphlet about the judicial branch's court service centers and law libraries is available in this jury room. The pamphlet will tell you if there is a center or a library in this court location. Thank you again for your service today.